The Joint Contracts Tribunal, JCT, recently launched its 2024 Design and Build contract, now including a clause reacting to the UK Supreme Court's triple point case. This clause permits liquidated damages to accrue between the completion and termination dates, clarifying they won't apply post-termination. This video delves into the triple point case, the resultant legal clarity for businesses seeking liquidated damages, and the potential influence on Cayman Islands construction contracts.
Imagine this. You hire a contractor to build something amazing in the Cayman Islands, but the project gets bogged down by delays. Frustrating, right? Well, the triple point case centered around a software development contract governed by English law, but the principles apply to construction too.
The triple point case related to a company called PTT, the employer, employing Triple Point, the contractor, to replace and develop a new software system. The contract envisaged that the contractor would be paid a portion of the contract price on the basis of achieving a certain number of milestones. However, the contractor only completed 2 milestones and then abandoned the site, and the employer subsequently terminated the contract. The contract included a liquidated damages clause, which is basically a pre-agreed amount of money the contractor pays if they're late. Sounds straightforward, right?
In the triple point case? Not quite. The project was never actually finished, and there was a disagreement. Could the employer still claim those liquidated damages, even for the unfinished work?
The plot thickens. Initially, the claim was granted in the employer's favor, and they were awarded liquidated damages for delay up to the date of termination and to its general damages arising from the termination. But the contractor appealed the decision, and the Court of Appeal held that following termination of the contract, the employer was not entitled to claim liquidated damages in respect of incomplete work, and that liquidated damages were, therefore, only available to the point where works have been completed.
There was a sharp intake of breath among many construction lawyers following the Court of Appeal's decision. Whilst there was no absolute authority, received wisdom based on first principles, and even set out in textbooks, was that an entitlement to liquidated damages once accrued would remain in place at termination and could be sued upon regardless of state of completion of the works.
The immediate effect of this decision was that parties who had negotiated and agreed fixed damages for delay were now being told that the bargain that they had struck had changed. Having agreed a rate of liquidated damages, the employing party, whether employer to contractor or contractor to subcontractor, were being put to the time and cost of proving their actual loss as a result of delay. But then came the big twist. The UK Supreme Court overruled them, unanimously allowing the employer's appeal, finding that the right to liquidated damages remained an accrued right, as at termination regardless of whether the works had been completed, stating that the Court of Appeal's decision was inconsistent with commercial reality and the accepted function of liquidated damages.
Local laws and regulations in the Cayman Islands will determine how this ruling will ripple through our construction contracts. However, it's fair to say that the result of the Supreme Court's decision is that construction lawyers here in the Cayman Islands can now breathe more easily, because parties to contracts now know that, absent of clear words to the contrary, the orthodox position is that where fixed damages are agreed, then those damages will apply up to the point of termination.
Contracts based upon a Caymanized 2024 JCT contract will include the new clause referred to in our introduction, which will serve to harmonize the common law and contractual positions on the application of liquidated damages. But for other forms of contract, for example, those based upon the AIA, FIDIC and bespoke agreements, we are of the opinion that the liquidated damages clauses should be reviewed to ensure that they make it clear that the orthodox position will apply. However, the Supreme Court also confirmed that liquidated damages may still be in play post-termination by the inclusion of expressly stated contractual wording. Therefore, for those desiring liquidated damages be payable until completion, irrespective of termination, we counsel that careful drafting of the liquidated damages clauses on a case-by-case basis will be needed to ensure that the mutually agreed intentions of the parties are properly reflected. But remember, the liquidated damages can't be excessive. They need to reflect a genuine estimate of loss from delays.
The key takeaway: when drafting construction contracts, pay close attention to those liquidated damages clauses. Make sure they're clear, specific, and proportionate.
By following these tips, you can help ensure a smoother ride for your next construction project, even if delays pop up. However, if you have any questions, please call Kevin Drysdale on +1 3459256101 or email him at kevin.drysdale@castlek.ky. And remember, this is not legal advice. If you have specific questions, consult a qualified Cayman Islands attorney. Thanks for joining us today.